Very good afternoon, everyone. So today in this session, we are going to start with, as I already said in the studies class, we completed articles of association to some extent. 5 was completed. We have 2 other small sections, namely section number 14 and section number 18. Once those 2 sections 14 and 18 are completed, we will be done with the concept of articles of association. Then we are going into the area called as doctrines under the Companies Act. Please everyone, there are 3 types of doctrine: doctrine of constructive notice, doctrine of indoor management, doctrine of ultra vires. So those are the 3 topics we will be discussing today. Once completed, we will be seeing effect of memorandum and articles, section number 10, and memorandum and articles to override. Next one, copy of memorandum and articles alteration. All those related concepts will be completing out. So first let us focus on section number 14 and section number 18. Please come to the Bayrak section number 14. Please come to the Bayrak section number 14. So the topic is, hello, enough, please listen. So the topic is alteration of articles is the concept. Name of the topic is alteration of articles. So articles alteration will be discussed in this particular area. So let us first try to understand what is the entire concept of alteration of articles. Then we will be going into analysis. First, like memorandum, in articles there will not be complication, because alteration of articles is just alteration of any points inside the articles. Memorandum la problem is, alteration of memorandum does not just mean alteration of a memorandum. It means clauses has to be altered inside. So we have read in depth about name clause, alteration, situation clause and its alteration, objects clause and its alteration. Clause wise we need to alter everything in case of memorandum. Articles la clauses will not be there. Therefore just we have to alter the nature in which it is provided, that's all. Easy way articles can be altered. Articles alteration is easier, difficult when compared to memorandum means articles alteration is very easy, except when there is a situation of entrenchment. Yesterday, if you remember, entrenchment concept I discussed in the class. Entrenchment is a concept where we will be providing restrictions in altering the articles. Generally, alteration of articles requires a special resolution. But when any point of articles is subjected to entrenchment, that provision alteration will require restrictions more than special resolution. It can be a special resolution plus 50% members, they will write accordingly. So whenever there is an entrenchment provision, it makes alteration more complicated and more difficult. I am not telling it is prohibited, but alteration will become more restricted. More difficult it will become, more complicated it becomes. That's what we have seen. To insert the entrenchment, we require unanimous approval in case of private company, special resolution in case of a public company. This is the next part that we have learned in the previous session with regard to entrenchment provisions. Now we have completed that. We came to section number 14, alteration of articles. Small section only. Let us first try to read the provision as it is from the Bayrak. Everyone, start the Bayrak. Subject to the provisions of this Act and the conditions contained in the memorandum, if any, a company may, by a special resolution, alter its articles, including alterations having the effect of conversion of private company to public company to a private company, provided that where a company being a private company alters its articles in such a manner that they no longer include restrictions and limitations which are required to be included in the articles of a private company under this act, the company shall, as from the date of such alteration, cease to be a private company. Means automatically it will become what? Where it was said there, automatically it will become a public company. Read again. First thing, there are two types of conversion. One, public to private. Second one, private to public. To become private to public. To become, I need to remove the restrictions and limitations. Insert. Private company restrict total number of members to 200. Restriction on transfer of shares. Limits total number of members to 200. Prohibit the public subscription of security. Do you remember or not? If I remove them, it will be a private company. Then it becomes a public company, he said. Yes, public company is any company other than private company. Automatically, if you are not a private company, you will fall under the category of public company. That's how it was drafted. Everyone understood the concept clearly? If you are not a private company, already we read the definition of a public company. Public company means a company which is not a private company. Automatically, when you cease as a private company, you will become which company? Public company. That's the idea of law. Okay. So, next, provided further that any alteration having the effect of conversion of public company into a private company shall not be valid unless it is approved by an order of central government on an application made in such a form and manner as may be prescribed. Next, provided also that any application pending before the tribunal as on the date of commencement of Companies Amendment Act 2019 shall be disposed of by the tribunal in accordance with the provisions applicable to it before such commencement. In this proviso, please write down not applicable. This is called as a transitory provision. Transitory provision means no validity today. 2019 amendment time la this point has a relevance. Now it is not having any relevance. Transitory provision. Next, continue. Every alteration of articles under this section and a copy of order of central government approving the alteration as per subsection 1 shall be filed with the registrar together with a printed copy of altered articles within a period of 15 days in such manner as may be prescribed, who shall register the same. Any alteration of the articles registered under subsection 2 shall, subject to the provisions of this act, be valid as if it were originally in its articles. So first 2 minutes time, read from the beginning till the end except second proviso to subsection 1. I mean third proviso. Please read, don't waste the time. Completed? Completed everyone? First point number 1. If you want to alter the articles, first number 1, you need to comply with the provisions of this act. Subjected to the provisions of this act only you have to alter. Okay? That means whenever you make an alteration to the articles, that altered articles must be according to the provisions of a Companies Act. That means you can't alter into whatever you want. It should follow the provisions of Companies Act. Second one, if there are any conditions in memorandum, if you write anything in the memorandum, okay, so you have to provide for the articles also in the same way. Example I will give you. See here, Memorandum of Association, objects clause, please. Memorandum of Association la objects clause la other objects are there. Other objects. In this, I didn't write anything regarding loan. Whether company can take a loan or not, I didn't write anything. Please listen everyone. Be here. Bro, for you only. Don't pretend please. Where you are seeing? Sir, okay, listen please. Memorandum of Association, objects clause, in that other objects or two types of objects will be there or not? Object number 1 will be main object, other objects and incidental objects also called as ancillary objects will be there. In the ancillary objects of the Memorandum of Association of a particular company, in that loan should not be taken. That means loan taking is not within the powers of the memorandum of a particular company. Clear everyone? I am now trying to make the alteration to the articles saying that board of directors of the company can take a loan up to rupees 10 lakhs. Now answer my question clearly. As per the articles of association, articles are nothing is there. Now I am trying to alter the articles and add a point. Okay, previously articles also silent. Now I want to put a provision in the article saying that, what I want to put? Board of directors can be empowered to take what? Loan worth how much? 10 lakhs. Up to 10 lakhs they can take on their own. Actually loan can be taken by MOA, cannot be taken. Come from the beginning once again everyone. Memorandum of Association is permitting taking the loan, not permitting? Answer. And a company can take a loan, cannot take a loan? Company cannot take the loan. Point is very clear. Second one, articles of association, they have written that board of directors of the company can take a loan up to how much? They want to add this. This is an alteration they want to make. Can they make it or not? You should only tell me. Why? When the objects clause is prohibiting you from taking a loan, who the hell the articles is to say that? That's what they mean by conditions contained in the memorandum, if any. Clear everyone? If memorandum is not permitting something, you should not do that by altering your articles. First you have to alter your memorandum objects clause. Clear or not everyone? So tell me, articles and memorandum, if you tell, MOA should be subjected to AOA, na? AOA should be subjected to MOA, na? Should be subjected to MOA. When it comes to applicability, superiority will be given to MOA. First MOA, next AOA will come. Tell me, contents of MOA are subjected to AOA, contents of AOA are subjected to MOA, na? Are subjected to the contents of MOA. That means MOA I didn't write loan. Then how articles can altered and said like that? Therefore, two things: subjected to the articles, subjected to the act and subjected to the memorandum. Means by following the compliances of act and memorandum, then only you can make the alteration to the articles. So if anyone asks you how to alter the articles, what is the first thing we need to tell? Subject to the act, subject to the memorandum. First condition, follow the act, follow the memorandum. Third step is shareholders by passing a special resolution in a general meeting. Everyone answer. Ordinary resolution means how many persons has to vote in favor? More than 50. Everyone repeat. What is it? Special resolution means how many members has to vote? 75%. It may be 75 or more than 75. But here it should be more than 50. Tell me. 100 members attended the meeting. How many should vote in favor? 51. 200? 101. 500? 251. 1000? 501. This is simple majority. Also called as a ordinary resolution. Clear? Huh? Special resolution. 1000 attended. 780. 780. 750. No. 75 or more than 75. Yes or no? 1000 plus 720. No. Because special resolution require 75% voting share. That means 3/4 has to vote in favor. Clear everyone in the class? This is one important point we need to understand. So therefore, tell me everyone in the class, articles of association can be altered or cannot be altered? Can be altered, subjected to the provisions of the act, subjected to the provisions of the memorandum. You can alter your articles. Shareholders permission required or not required? Required or not required? Okay, now answer. Subject to the provisions of this act. Can you give any example? You may ask me. Sir, you said example for memorandum, sir, I understood, but how to understand subject to the provisions of this act? Listen. Whenever you want to alter the articles, idea should come to whom? Everyone. Board of Directors will get the power from which section? 179. That's subject to the provisions of this act. First, idea should come to the board as per Companies Act. Under which section? 179. In the previous classes also I said this point, if you remember. Whenever we read the concept of alteration of memorandum, all the concepts, one common point is there. First idea will come to whom? Board will get the powers under which section? Already we completed that or not? Same. That's called as subjected to the provisions of this act. First you should comply with the act. In that, board has to take a initiative. After that, check whether the provision is there in the memorandum or not. Later you alter your articles. Hope up to here everyone understood the point clearly. One line we completed now. Okay. One point we completed. So, simply to understand, first initiative should be taken by whom? Initiative should be taken by whom? Board of Directors. Second one, after board taking initiative, we need to take the approval of whom? Shareholders by passing a special resolution in a general meeting. Second condition. Everyone understood? These two are subjected to the provisions of the act, subjected to the provisions of the memorandum. First line we completed. Hope everyone understood subsection number 1. Listen now. Whenever you want to alter the articles, yesterday we already read table F. In that, how many points are there? Everyone in the class? Say, for example, for simplicity's sake, answer. In my company, we made a full adoption. I think you know what is a full adoption. How many types of adoptions are there? Number 1, partial adoption, nil adoption. Say, for example, for simplicity's sake, I made full adoption of table F. Clear? Huh? I made a full adoption of table F. Now you should only answer. If I make a full adoption of table F, hello, listening? If I make a full adoption of table F as it is, I will copy paste or not? 65th provision in articles. 91 la 65th. Example, random number. I want to alter that. I want to alter 65th article provision. Clear? I have to take the permission of the board of directors. Next I have to take the permission of the shareholders. Then you can alter your articles. Okay? This is the point. But I don't want to disturb any of these clauses. I don't want to disturb you, not even a single point in that 91. I just want to remove the name private or add the name private. Everyone understood the point or not? I want to come from the beginning again. Tell me. I'm talking about what? I know after 2 o'clock lunch break after class is always dangerous. But I am more dangerous than that. Okay. Why you will sleep, I will see now. Okay. Challenge? Answer now. Point number 1. One second. I am just waiting to complete the Bare Act discussion first. Okay. Let me complete this. After that I will see why you will sleep. Okay. See here. Some people are thinking that sir has seen me. No, I didn't see anyone. No revenge on any one particular person. Revenge on class. So listen. So RRR la R revenge, inko R revenge, third R revenge. So listen carefully. So listen carefully to the point. 2 to 4 is very dangerous. That time na Rakshasa Muhurtam. So I know, very dangerous. But still, we are more dangerous than them. Listen carefully. Point number 1. Listen. I am not changing any of the 91 points. I am not touching them. I am just changing the name la private to public. Means you should understand. I am trying to make only conversion. Private to public, public to private. Either I want to convert private company to public company, or I want to convert public company into private company. You should only tell, I want to convert public to private. What I should do? Delete the word private, add the word private. Public to private. Private to public. Public to private. Public to private. Delete the word. What he want to convey in this particular concept is not only changes in the 91 clauses requires special resolution. Special resolution is required also for adding and deleting the words. Which words? Private. I repeat, 91 points are there. Say for example, sorry, I have written my own articles. Can it be 200? Yes, yesterday I told you clearly. You can have your own articles. When you start writing your own articles, a number should be restricted to. Madam, please listen. Number should be restricted to 91. Number can be more than 91. Can it be 200? In that 200, one point I want to change. I want to change one of the point inside the 200. Okay? That requires special resolution. No doubt in that. I don't want to touch any of the main contents. ABC Private Limited, I want to make ABC Limited. Or ABC Limited, I want to make it ABC Private Limited. Either I want to add private or I want to delete private. Small change I want to bring. Even though that's a small change, will it require a special resolution? Obviously it require. Also in name clause concept we have seen this, if you remember. What clause change? Do you remember name clause alteration? There it is required. Now answer my question clearly. One second please. Whenever I am converting public to private or private to public, everyone, public to or private into public, you are changing it. Private to public, if you convert, restrictions and limitations will be added, will be taken. Added, taken. Taken. I want to convert public to private. Limitations and restrictions and prohibitions are added. Now answer. Name will change. Memorandum alteration. Restrictions will be added in articles. Articles alteration. SR1, SR2. Everyone, now do you understand what I tried to say? That's why I said wake up, listen properly. 2 alterations are required. One alteration is MOA alteration for changing the name. Next alteration is to add restrictions, limitations or prohibitions, or to delete restrictions, limitations and prohibitions. Hope everyone understood the point. When called on the stage, I should not listen wrong answers. Everyone. Second row. First row. Second. second, third, four, ಇಲ್ಲ 4, 5, 6, 6 and not this, 6, 7, only you two people. Thank you. So you are not fifth row, you are not fourth row, you are 3.5, 4.5, sorry. So listen, whenever you want to alter whenever you want, for example, you should tell me the point now. ABC Limited, I want to change to ABC Private Limited, or not working. Answer now. ABC Limited, I want to change to ABC Private, or listen please, ABC Private Limited, I want to change to ABC Limited. Now everyone answer, what procedure you have to follow in this? Sir, first tell me this, easy, this is easy. Tell me. I am asking you this question. First, it is which company beginning? Now it is converting into? Now tell me, what procedure you have to follow? First idea should come to the, later they should go to the, pass which resolution? Eka doa, ek MOA alteration. Why MOA alteration? Adding the word private, deleting the word private. Deletion of the words private. MOA altered, done. After that you will file the altered MOA with the ROC. ROC will register your altered memorandum. This is all about name clause alteration. Now come to articles. Articles we are adding restrictions, limitations and prohibitions, removing restrictions, limitations and prohibitions. That means our articles should be altered or not? Those altered articles requires what resolution again? Special resolution required once again. Hope everyone had a full clarity on this now. Done. Happy. 1 point over. Now tell me this one. Again not working. Thank you very much. Okay, see here. Okay, see here now. ABC Limited, sorry, listen please. ABC Limited is getting converted into what? ABC Private Limited. Again, Ghana go, start from the beginning. First we need to alter. First idea should come to Board of Director. Alteration of, adding the words private, deleting the words private. Name clause altered, filing with ROC, everything you go there and read again. Okay, third point. After that, next issue is once you alter MOA, after that you need to alter your AOA. AOA if you want to alter, first again shareholders has to pass the special resolution in a general meeting. Alter your articles by adding it. Everyone understood? Now tell me, first situation la private to public, public to private first. Second one, which is more damaging, first or second? Second, because there are 10,000 members in a company. Suddenly they are becoming a 200 members company. listed company becoming unlisted. Very dangerous or not? Therefore, second one requires central government approval. Therefore, this one requires which approval? Central government approval. Please read the provision. Provided further that any alteration having the effect of conversion of public company into private company requires the approval of central government. Mama. Swaha. Everyone understood the point clearly, yeah? So whose permission is required? Central. In all cases, no. When public conversion into private is more damaging and dangerous, therefore it requires the central government permission. In all other cases, it's not at all required. Clear, everyone? Done with this proviso. This proviso anyway not applicable. Remaining concept is same, sir. You have to alter your articles. Okay, na? Now tell me, listening everyone? Altered articles, original articles, which is more superior? Both are same. No one is superior because alteration is also approved by shareholders. Original is also approved by shareholders. Alteration or original articles filed with ROC. Altered articles has also to be filed. Therefore, subsection 2. Every alteration of articles under the section copy of central government. Sir, when the copy of central government has to be required? Public conversion into private. CG has to give its approval. That approval copy. Altered articles approval copy shall be filed with the registrar within a period of how many days? 15 days. You will file. Tell me, altered AOA, original AOA, which is superior? Both are having same impact. That's what subsection 3. Any alteration of articles registered. Any alteration registered. Tell me, any alteration of articles? Bad swing. Tell me. Whenever the articles are registered, then only they will get the validity. You prepare your AOA, no effect. No effect. No effect. Totally no effect to that. No impact. Sorry, next stage. So shareholders approved. Same. Likewise, unless and until it is registered with ROC, don't have any legal impact. Clear? So therefore, the alteration of articles registered under subsection 2 shall subject to the provisions of the be valid as if. The words used are as if. As if means what? As if means what? As if. As if means deemed fiction. That means how original is prepared. In the same way, altered as if like original, I will also take this into consideration. Means altered AOA, original AOA, which is having more impact, both are having same. As if they were originally in the articles. That's all. This is the idea behind the concept. Everyone understood this section? Everyone in the class? But for my satisfaction, you answer. I should clap for me. Okay, I should clap for you. Answer my question one by one. Which section we completed now? Section 14. What section 14 said? Tell me, alteration of article, first idea should come to the subjected to the provisions of Act and MOA. Next, first idea should come to approval must be given by passing a in a very good. Number 3, very very important. I just want to convert public into or private into. First alteration is MOA. Next alteration AOA. MOA leave off. I am not asking. AOA tell me. Same procedure has to be followed. But if the conversion is a public-private conversion, means public into private, it also requires whose permission? Next, altered articles 1 copy, central government approval 1 copy, attach and file it with the ROC. Within how many days? Within 15 days. ROC will register them. It get the legal impact as if it is original articles. That's all. This is about section number 14. Everyone understood the point clearly? Yeah? But one small interconnection is there. That's section number 18. Please come to section 18. Once all these are completed, section 5, section 14, section 18. Some great people will come to the stage and share their views. Yeah, correct. Alteration. Alteration. If nothing is written, you can file, no problem. 15 days. From section number 18. Yes. One second. Hello. Hello, one second, please. Please, everyone. Ask the door. We don't require central government approval under that section is not required. There, undesirable names concept of central government permission not required. Here, concept is different. But very good question. What he is asking is, there in the name clause of memorandum when we read, I said central government permission not required just to add or delete. Yes, true. Under name clause concept, why we apply for central government under that section? Central government will check undesirable names, etc. Under that section, it is not required even now. Hello. If that is also required, 2 CG approvals are required then, not just one. Here only 1 CG approval, that is only for what? Alteration of articles and public converted into private means so many changes will come. It will check whether they are properly incorporated into your articles or not. Not for name cause. Not for name cause. It is for alteration of articles. Whether the prepared articles after the conversion are proper or not, they will check. Who will check? Central government. For that reason, central government approval. But very good question actually. Next, section number 18. Please read section 18. Concept idea. Conversion of companies already registered. Sir, what do you mean by conversion of companies already registered? Already we read na conversion. No, I am not talking about that conversion. What conversion they are talking is non-profit company converted into public company, non-profit company converted into private company, one-person company converted into public company. Clear everyone? All these kinds of conversion, various types of companies we have seen. Those company interchange if there is, this section will get attracted. Let's read the point. Start. A company of any class registered under this act may convert itself as a company of other class this act by alteration of MOA and AOA, not MOA or and of the company in accordance with the provisions of this chapter, where the conversion is required to be done under this section. The registrar shall, on an application made by the company, after satisfying himself that the provisions of this chapter applicable for registration of the company have been complied with, close the former registration of the company, and after registering the documents referred to in subsection 1, issue a certificate of incorporation in the same manner as its first registration. The registration of company under this section shall not affect, this is affect, not effect. This is influence, impact. Shall not affect any debts, liabilities, obligations or contract incurred or entered into by or on behalf of the company before conversion, and such debts, liabilities, obligations and contract may be enforced in the manner as if such registration has not been done. First read section 18 clearly. Take 2 minutes time. I am making it full screen. When I ask you to read, read properly. Completed? So first point, what is this concept all about? Whenever you want to convert any kind of company, class of company, if you want to change, this will get applied, including public private conversion also, everything, including, not just restricted to that, any conversion. I want to convert non-profit into profit oriented normal public company. I want to convert them into private company. I want to convert OPC into normal public company, private company. In all cases, any kind of conversion if you want, that requires compliance of section number 18. It's a simple concept. See here. Originally my company name is ABC Private Limited. Now it was converted into ABC Limited. Originally my company name is ABC Private Limited. After conversion it was changed to ABC Limited. ABC Private Limited became ABC Limited. Obviously this requires board approval, board of directors approval. Next one, shareholder special resolution is required. And after that, central government permission is also required. Central government permission, private to public not required, public to private is required. So board of directors, central government filing with the ROC, same. If it is a conversion of public to private company, first one, board of directors, next one, shareholder special resolution, next one, along with this, central government approval is also required. Next stage, filing will start. All these are common or not? Yes, along with this section will also get attracted. I think, listen carefully please. This section is not talking about permissions to be obtained. It is talking about what will happen upon conversion of companies. Three things will happen. Number one, if you see the screen, a company of any class registered under this section may convert itself into company of other class under this act by alteration of MOA, by alteration of AOA. Already we read this concept or not? I want to change limited to private limited. I just want to change articles. I also should change name clause. Okay. I want to convert section and company into a public company. Name only will change. Objects also will change. Objects also will change. That means it requires only name change. Objects also change. Whenever you are converting a class of one company into class of another company, first thing that gets attracted is MOA alteration. First one. Second one will be AOA alteration. First one. Second one. Two things will get altered first. Okay. MOA alteration, AOA alteration. Two things will be altered. Everyone understood? Yes, done. MOA, AOA altered. Next stage. After this, board of directors, special resolution, everything will be there. So MOA, AOA alteration is the step number one. Number two, you will file all these things. Fourth point, third here, fourth here. You will file it with whom? Where conversion is required to be done, the registrar shall, on an application made by company after satisfying himself that provisions are properly complied, he will close the old certificate of registration and he will issue a fresh certificate of incorporation. Originally my company name is ABC Private Limited. Now converted into ABC Limited. Same certificate, different certificate. Again you have to take a different certificate of incorporation. Now I want to ask a question, answer. My company is ABC Private Limited. This particular company is having a balance sheet. Balance sheet there are around 1 crore worth creditors. Now I converted this into public company, ABC Limited. Same company, everything is same, just name a change. Creditors came to me and asked to pay my money. I said go and ask ABC Private Limited, not me. Valid or not valid? Debts, liabilities, obligations, contracts. Everyone repeat all the four. Debts, liabilities, obligations and contract. Will close, will continue. That's all. Section 18 also over. Nothing great, sir. Section 18 is a small section. Now you complete this in 3 parts. First part number 1. I want to convert one company class into another company class. Step 1. Alteration of MOA, alteration of AOA. Second one is what? Alteration of? That already we completed in 14. Already we completed that in 14. Okay, so no need to read once again. So MOA already we completed. AOA already we completed alteration. So MOA alteration, AOA. That means this section has to be read after completion of all alterations. That's why we are reading 18 after 14. MOA completed, AOA completed. Tell me, I want to convert section 8 company into a normal public company. It is required only to change name. It is required also to change objects. First, what should change? Name. Second, objects. Third, capital will change. It starts issuing shares to public, na? Number four, association clause may change, may not change. Okay. So liability clause same, limited liability, there also limited liability. Everything will be same. But 2-3 clauses will change or not? Next, answer my question. After that, third one. Alteration of articles is required or not required? When I want to convert a section 8 company into a profit making company, articles will change or will not change? Will necessarily change. We want to change them. So alteration of articles, alteration of memorandum, both are required. We will alter both. After that, file it with the ROC will cancel old COI and will issue new COI. Clear? Once I am issued with a new certificate of incorporation, old debts, liabilities, obligations, contracts will continue, will close. In old name, in the new name. That's all. This is all about section 18. Please read section 18 before we go to the next one. Section number 18. Take a minute time, complete them fast. I will show you the charts also on this. After that, great people will come. I will never forget. You do one thing, read from here directly. First, everyone, see the screen. Again gone. See here. See now. What is the provision? Please. When I start asking the questions, don't make mistakes then. Please see the screen, everyone. What is the section we are going to read? Section number 5. Articles of Association. Again gone. Again gone. Okay, see this? Array. Each. See here. So what is the section we are going to deal with? Section number 5. What is the topic? Articles of association. First, let us see the content clearly in detail before we make an analysis. Start. Definition. What is AOA? AOA means AOA as originally framed or AOA as altered from time to time. Next one, characteristics of AOA. Basics. Contents. Contains what? Regulations for management of company. Model articles and its impact. Tell me, what model article? So, see here. Effect of model articles. Tell me. Model articles will provide matters for what? Management of company. You should only tell what are the tables of articles? F, G, H, I, J of schedule number 1. Next, company may provide for additional regulations. Yes. Now tell me, I have to adopt all table F. All or any? Those are the 4 points we read there. Completed. Next, entrenchment of AOA. You people only should tell me. Entrenchment means imposing restrictions or removing the existing restrictions. First question number 1. I want to impose restrictions. How you can impose the restrictions? By passing a unanimous approval in case of a private company, by passing a special resolution in case of a public company. Permission will be given to entrench. Now tell me, after entrenchment, can I alter that provision? No. But I can alter only by complying with the provisions less restricted than special resolution or more restricted. Just now we read, alteration of articles require which resolution? Not answering. Alteration of articles require which resolution? If entrenchment is there, the same alteration will require special resolution plus other conditions also will be required. But to insert entrenchment, we should pass unanimous in case of private and special resolution in case of public. Sir, no sir, company are not at incorporate. The time of incorporation of company I want to entrench. In that case, no approval required, directly you can include the entrenchment provisions. Sorry, next. After that, this is what we have seen. Entrenchment of AOA. Meaning of entrenchment, imposing conditions on alteration of AOA which are more restrictive than special resolution. Next, imposing entrenchment provisions. When you can put at the time of incorporation, after incorporation. If you want to put at the time of incorporation, no approvals required. After incorporation, private company na unanimous, public company la shareholders by passing a special resolution in a general meeting. Next, alteration of AOA. Step 1, board of directors approval. Step 2, shareholders by passing a special resolution in a general meeting. Compliances. Comply with Act, comply with MOA, file copy of SR and altered AOA with the ROC within next. Sorry, it is 15 days. Please make a change in the I will make a change today itself. Maybe by mistake it might have been. Next, ROC will register the change. ROC will register the change. That's all. This is all about alteration of articles. First point number 1. All the points in the Bayer Act has been covered in the chart, sir. Yes, sir. Next. What is the next one? Conversion. You may ask me a question, sir. In the chart, where is conversion? So you forget. Alteration of article section 14, what we read? Conversion of public, private, central government we read na? In this chart it is there. Therefore separately I kept in this chart. That's why I have written conversion cases section 14 read with section 18. All kinds of conversions I kept here. Clear? Now let us read this chart also. Your questions now will be on this chart and previous one. Read basic conditions. First conversion. What conversion is covered? Any class of company into any other class. Conditions. First one, alteration of MOA, alteration of AOA, shareholders bypassing a special resolution in a general meeting, board of directors in a board meeting. All are already discussed or not? Yes. Next, after that, compliances required. Refer note, section 14 and 18 to here I have written. Okay, read. Company has to file a copy of special resolution and the copy of altered articles and a copy of central government confirmation to the ROC within a period of 15 days. Here I have written clearly, within a period of how many days? 15 days. Debts, obligations, contracts shall continue in the name of converted company. But one small important point is there. Conversion of OPC into Section 80 is not permitted, except that all conversions are permitted. Conversion of what into what is not permitted? OPC into Section 8 not permitted. Section 8 to any other is permitted. OPC converted into Section 8 is not permitted. Everyone understood the concept clearly? Yeah? Next. Why OPC I will tell. Why OPC it will come not here. Okay. Next. Additional conditions in special cases. Conversion covered. Please read private into public or public into private. And compliances. First conditions as specified in section 18. You comply with all those things. Next, type of conversion. Two types will be there. First one, private to public. Answer, you should only answer. Private to public, it will impose restrictions, limitations and prohibitions. It will remove. Public to private, include. Central government approval is required only if conversion is made from public into private company. Clear everyone in the class? So we now have completed. What are the three sections we completed now? Section number 5, 14, 18 is also completed. Clear, sir? Everyone in the class understood the point? Yes, separate resolution. Yes, that's why they didn't tell one special. They said alteration of MOA. If you are altering name clause, change the name once. If you want to change the objects, objects change again. Register office again. Always SR, I said in the class so many times, multiple SRs has to be passed. Each and every business you want to approve, one special resolution is required. If you have 7 changes, 7 special resolutions are required. Public to first alter the MOA, requires special resolution. Then AOA. 3 and first one? Yes. MOA ne change in name kada. Change in MOA itself means change in the name. That's our name may change. One special resolution. Second one is to alter article. 2 special resolutions. If you change capital clause, amount will be same kada. Name may change. Amount will be same. Whether it is private or public or remove of. Limited liability is always a limited liability. Whether it may be private limited or public limited. Limited liability is always limited. So no need to change capital clause unless and until you change the authorized capital. First you need to change MOA. Then you need to go for AOA. That's why always I will write MOA and AOA, not AOA and MOA. Sequence is common. I will give you 2 minutes time, max 3 sections. 5, 14, 18. You read. After that I will call the people on the stage. You will be answering. I am giving you 3 minutes time exactly. 1 minute for 5, 1 minute for 14, 1 minute for 18. More than that not required. Read from the charts. If you have. If you don't have, read from the normal Bear Act. Section number 5 completed, everyone. 5. Entrenchment also. Very good. Next, read 14. 14 and 18 combinedly you have to read. Completed reading? Completed? So, can you please bring the second mic? Is it working? Check it. No? Batteries are there, please. Battery is there. Battery is working. Now try. Working? I'll give it. So see here. So let's continue with the questions. So we have completed section number 5, 14 and 18. 5, 14 and 18 la, I am now going to ask the questions. Section number 5 talks about alteration of, articles of association. Section number 14 will be alteration. Section number 18 will be conversion of the classes of companies. Okay. So who will come? Anyone interested to answer? 1, 2, 3, 4. That's all. That's all. 1, 2, 3, 4, 5. Only from boys. 6. Anyone? No one, na? Sorry, from boys, okay, 6 are there. From the girls, not even one person. Who will come to answer? 7. Sir, then I will only make selection. One person. That's better always. See here. Question number 1. For whom? And a black t-shirt, Puma t-shirt. Puma t-shirt. Abba, don't do over action. You know that you are the one. Come. Aja. You read the section, Bro, read the section? Very good. Come. Come. Stage awaits you. Come. Stand in the middle. Be confident. Take mic. Easy questions. Question number 1. What are the 3 sections we are discussing now? See them. Number. Mic switch on.
Section number 5, articles.
Very good.
Alteration of articles. Section number 14, conversion of companies register under.
Okay, section number
18.
Very good. Next. Not yet complete. It's section numbers ke. This is the over action. So listen. Now, tell me, what do you mean by entrenchment?
You have to change the.
1 second. Come here. Stand here. You stood here. Again, slowly you went. See them. Keep it near to your mouth. Loudly answer.
Entrenchment gives the more restriction for the changing articles.
Very good. Next, I want to include entrenchment. Okay, at the time of incorporation, I want to include. What to do?
No.
Tell them, yaar. Why you are telling to me?
No permission is required.
Very good. Next, second question. You want to change the articles after incorporation through entrenchment. After incorporation, you want to include entrenchment. To include, whose approval is required in case of public company? Public company, what resolution is required? Private company, unanimous.
Special resolution.
Thank you. Tell them.
Special resolution.
Thank you. Next. This row, one person came. Next test from this row. Bro, yellow t-shirt. The person at your back. Come. Da. Come here, stand. First, உன் பேர் என்ன?
Strians.
எஸ்டி ஓகே சரி. Question number 1. What are the 3 sections we are going to discuss now? Are we completed now?
Section 5, Section 8.
See them.
Section 5, Section 18, Section 14.
Okay, next see them. Don't see me. Voice say it will come from here. Answer them. Next question. Question number 1. I want to alter the articles of association. What is the procedure involved? Explain. Tell in easy language, no problem. You need not tell the Barak language. Just in steps you tell. Don't see them, they can't give you any prompt. First point number 1, I want to alter my articles subjected to provisions of subject to the provisions of. And I said one example, subject to the provisions of Act and subject to the provisions of Act and
MOA.
very good. Next, first who should take an initiative?
Board of Director.
Arey loudly tell yaar.
Board of Director.
Very good. Next, to whom I should go? Hey, don't prompt.
Special shareholders
Uh.
in general meeting by passing a special resolution.
Special resolution. Very good. Next, I have to file it with. File it with whom? One person will be there. ROC. Very good. Next, what is the content covered by section 18? Heading of the section. Section 18 heading.
Conversion of registered company.
Conversion of.
Registered company.
Arey loudly tell. Even I
Conversion
can't
of a
listen.
registered company.
Sir, a conversion of a company registered. Thank you. Listen again. Listen to the class properly. Next. This row over. Last row. You do one thing, you people pick one person who is more popular in that row. Who is that? Rishia. Who is that? Da badi da. Da. That's why never you should become popular. Very popular also in last bench. Both conditions you satisfied. Come. Da. Question for you. Question for you. What are the 3 sections?
Section 5 articles. Section 5 articles. Section 12 alteration of articles. Section 14.
Section 5?
Section 5 14 18.
14 and
Alteration of articles.
18?
Company conversion of company already registered.
Okay, next. I want to convert companies already registered. What is said in section 18? 18 la what section? Section 18 contains what? 3 subsections are there kada?
Yes sir.
Tell me. Tell them. First, I will give hint. Answer. Alter.
Alter MOA for name clause.
Name of leave.
Sir. Okay sir.
MOA, okay. Name, objects, who asked you? I didn't ask. Example I said to class. First, alter.
MOA.
Loudly.
MOA.
More loudly.
MOA.
Next, after that alter.
AOA.
Tell them. Come here.
AOA.
Come here. Stand here. Tell them.
AOA.
AOA. What AOA?
Articles of Association.
He said. Okay, AOA alteration, MOA alteration. Next, after that you have to file it with
ROC.
what ROC will do? Eat and sleep, what ROC will do? Tell what ROC will do. Fastly tell what ROC will do. Without saying that, tell answer directly. What ROC will do?
Issue of new certificate of incorporation.
First. Like that you should. Tell. Issue of?
New certificate of incorporation.
Then what about old? Who will take it?
Register of
Huh?
ROC, sir.
ROC will take it.
Yes, sir.
Which one?
Old one, sir.
Old one cancel here.
Yes, sir. That only, sir.
He only said ROC will take. He is only telling he will Hey. Come here. Next, last point.
Yes, sir.
Last debts, obligations, liabilities, contracts. What will happen?
It will continue, sir.
Thank you very much. Nice to meet you. Next. Anna, come. You, Hoodie, come. You know that you will come today. Not else. Question number 1. What are the 3 sections?
Section 5, Section 14 and Section 18.
Next, very good. What is 5?
Alteration.
Hey. What is Section 5?
Association.
5?
Article of Association, sir.
Hey. Articles of Association. Next, 14.
Alteration of Article of Association.
Very good. 18.
Section 18. Change of company already registered.
Very good. Okay, sir. Okay. Next, tell me, I want to provide for entrenchment. Okay. What is the procedure? Complete procedure of entrenchment. I will give a hint. First, I want to entrench the provision. At the time of incorporation, what permission is required?
First, Board of Directors.
Hey. Entrenchment. Entrenchment, do you know? What is entrenchment?
More restriction than special
Very good.
resolution.
I want to insert those entrenchment provisions at the time of incorporation. Whose permission is required?
At the time of incorporation, sir. No permission.
Very good. Tell them.
No permissions required.
Next, I want to insert it after getting incorporated in a private company. Whose permission is required? Private company. All means what permission? What approval? All.
Unanimous consent.
Very good. Next, public company.
Public company.
If not unanimous, next. Unanimous in private.
CG, government.
In the hint, no one will give unanimous approval. Okay. Which resolution is bigger after unanimous?
Special resolution.
Thank you very much. You go. Next. From the. So many questions are still there. We will play with them in doctrines. Doctrine style. Fill the game. Next. From this row, who will come? Anyone is interested? Then I will only choose. They are hiding somewhere. Last bench. Madam, come. You are invited. Hearty welcome to stage. No. That person. You come. Hearty welcome. Case invites you. Take this mic, stand there, answer them. Question number 1, same. What are the 3 sections?
Section 5, Section 14 and Section 18.
What is 14?
Alteration of AOA.
What is Section 5?
Articles of Association.
Very good. What are the tables contained in AOA?
F to J.
Yeah?
F.
Madam, tell all the names, please. F to J. F.
F.
After F. Yeah. A, B, C, D, E, F. After that.
F, I, J.
Table F. Very good. Next. Table F, G, H, I, J. Very good. Next. What is a model article? Meaning of model. Yesterday you class you attended. Noah? Noah, yes sir. Yes for Noah. Then sorry, answer this question. I want to convert public to private. What to do? I will give hint, no problem. First, idea should come to whom?
Board of Directors.
Loudly.
Board of Directors.
Very good. Next, go to
They have to get permission from shareholders.
shareholders by passing.
Special resolution.
Very good. Central government permission required or not required? Private to public.
Not required.
Private to public. Required or not required?
Not required, sir.
Thank you. Next. Another from this row. Who will come? Welcome. Madam, you come. Mask. I said, who wear mask will come on stage. Come. Today. We invite you. At least now remove mask. Nothing will happen. I don't have COVID. If you wear, we doubt you. You take it. Yesterday question I will not ask. Today's question I will ask. You can come. Question number 1. Answer them. Question number 1. What are the 3 sections?
Section 5, Section 14, Section 18.
Next. Model. Yesterday you were absent. Very good. Save. Day before?
Sir, actually, like for a week I was.
For a week you are absent. Today you are present. Very good. Today you are present. Today you are called on stage. A lucky person you are. Sorry. Today's question I can ask. Very good. I want to alter my articles. Tell me 2-step procedure. First, idea will come to whom?
Board of Directors.
Tell them.
Board of Directors.
Second, whose permission?
Shareholder.
Very good. By passing?
Special resolution.
In a?
General meeting.
File it with?
ROC.
File it with? Correct?
ROC.
Very good. Next, I want to convert public to private or private to public. Which section will get attracted? Think and answer. 1 section, 2 sections?
2 sections.
First section number 1?
Like memorandum.
Memorandum, okay. That you don't know, you didn't attend. Next one.
Association.
Which section?
Section 5.
5 is articles. Alteration of articles.
Section 14.
Very good. Thank you. Next. Sorry. In this row, another one has to come. Because one person didn't attend the class. Na? Who will come? Man, you come. Take this mic. You attended from the beginning. Then any question can be asked. Come. Question number 1. I want to alter registered office from one state to another state. What I should do? I will give hint. 1 second. I will give hint. Number. Listen here. Hint number 1. Will you stop talking, everyone? Please listen. Question number 1. I want to shift register office from one state to another state. Question number 1. Who will take initiative? Idea.
Board of Directors.
Tell them.
Board of Directors.
That's all. Same sound you maintain. Don't change the mic setting. Keep like that. Second one. I need to take whose permission also?
Members' permission.
By passing?
The special resolution.
In a?
General meeting.
Okay, next 2 questions over. I want to change from state to state now. Whenever I am changing, I will give the example at that time. What I said, you tell me. I want to change from a place like Chennai to a remote place in Assam with an intention to cheat whom? Maybe, chance is there. With an intention to... Did you remember the example I gave?
Yes, sir.
Intention to cheat whom?
The government. The creditors.
Very good. For that, what central government will check? Sufficient provision. Okay, you didn't remember. Sorry, very old. Sorry, okay, no problem. I will ask today's question then. Tell me, what is entrenchment?
restrictive
Tell them.
restrictive powers in the articles, like
Restriction on what?
restrictions in the articles, sir, like
No, entrenchment is not restriction on articles. Restriction on what?
power
Restriction on alteration of articles.
alteration of articles.
Next, question number 2. I want to entrench after getting incorporated in a private company. Which approval required?
Members approval. That is
Members,
unanimous.
okay. Which approval?
Unanimous.
Ordinary, special, or unanimous?
Unanimous.
Very good. Public company?
Special residence.
Very good. Next, I want to convert private company into public company. Okay? Sorry, public company into private company. I need to alter MOA or not?
Yes, sir.
Required, not required?
Yes, sir.
If yes, why required?
Sir, because if you need to alter articles, first we should alter the MOA.
No, not that is the reason. I told you another reason. You want to change the name of the
first.
company first. MOA. Next, what change will happen?
Articles.
Articles change. Next, file it with the
ROC.
ROC. If it is a conversion of public to private, along with all these things, whose permission is also required?
Central.
Thank you very much. Super. Next. Last 2 persons. Who will come? Anyone? Anyone want to come? Voluntarily? Huh? Sir, hey, listen here. Anyone? Whoever want to come, can come. Anyone? No one, huh? So, selection is in my hand. Then, ma'am, you come. Back. Please come. Come faster. Yesterday you attended, huh? Yesterday topic you remember? Huh? Konjam, huh? Parla. Take this, answer the question one by one. You come. Fastly answer the question. Question number 1. First, what is section number 14? Tell them.
Alteration of articles.
Very good. What is section number 5?
Articles of association.
Very good. What is a model article?
Model article is given by the
Which schedule?
schedule F2J.
No, that is table F2J.
Schedule 1.
Schedule 1. Okay, see them and answer the question. How many model articles are there?
5. 10.
20, 30. I am not asking about that. How many provisions are there in model articles?
91.
Very good. Next, can I change any one of the 91?
You can.
What are the 3 types of adaptations of table F?
Full adaptation, partial adaptation.
Okay, I don't want that. I want the meaning. What do you mean by full adoption?
Full adoption is when we adopt the entire 91 clauses of the model article.
Very good. A partial?
When we adopt the part of it, or if we alter
Very
any
good.
one
Next,
of it.
full, nil adoption?
When we draft entirely our own articles.
Very good, super. Thank you very much. Next, one last person who will come. Madam, you come. No, you attended yesterday's class? Yes, sir? Then come. Some people are there, Maya. I was saved for today. Next day again he will ask. So I will be prepared. Question for you. At yesterday's session you attended? Yesterday?
Yes, sir.
Very good. Then see them. I will ask the questions, answer. Model articles are contained in which schedule of Companies Act?
Schedule 1.
Very good. How many points are there in model articles?
91.
What are the 3 types of adaptations of table F?
Partial adoption, nil adoption, full adoption.
Very good. I have my own articles. Which adoption will work?
Nil adoption,
Okay. I don't write anything. Which adoption will work?
full adoption.
Next, articles of association I want to entrench at the time of incorporation. Whose permission is required?
No permission is required.
Very good. Private company after incorporation.
Private company.
company, anonymous
Okay.
resolution.
Anonymous means we don't know. Unanimous.
Unanimous
Next, I want to pass it in a public company.
special resolution.
Entrenchment means what?
Restricting the alteration of articles,
Which is more
which is
more restricted than passing what resolution?
special resolution.
Very good. Thank you. Super. So, one last question for our wild card entry. Come. ICA, come. ICA, you come now. Now I will ask you question, you answer. For a change. Easy question I will ask. Come. See. Simple question. You can't tell. You have throat pain? Okay. You can't speak? Okay then. So try. If you could not, okay. Slowly you try. Tell me, stop 1 second. What are the 4 things we need to keep when registered office is incorporated? Try the answer. When registered office is incorporated, outside the every place of business, tell them. First one.
Paint or affix.
1 second, please.
Paint or affix name and address of the registered office.
Where?
In all conspicuous places.
Okay, very good. First one. Next.
Seal.
On seal.
Name engraved in seal.
Name and address is required or not required? Very good. Third one.
Third one, all details like website, email address, name, registered office address.
Very good.
everything bills. And,
Invoices, etc. Fantastic. Next, last one.
negotiable.
Wow, super. Thank you. So, sir, everyone in the class confident about the topics complete up to here? Next one, we are going to start with the doctrines. Sorry, taggedele. Sorry. Arey, don't shout here. Hey, why you are shouting? 1 minute. 1 minute. Arey, 1 minute. Arey, 1 minute chance. I will remember everyone. Sir, take break and come. So let's continue. So before the break, we completed section number 5, 14 and 18. So everything has been completed in that. Next, we are coming into, so please, next area of discussion called as doctrines under the Companies Act. But even before the doctrines are concerned, please, some introduction is required with regard to this concept. Once after the completion, we can directly go into the 3 doctrines applicable for your exams. Doctrine of constructive notice, doctrine of indoor management, and doctrine of ultra wires. Meaning, ideology, concept, everything we will be discussing in the today's session. Will you please stop talking, everyone, please? Silence, please, everyone. So let's continue. So first one, totally there are 3 types of doctrines. Doctrine of constructive notice, doctrine of indoor management, and doctrine of ultra wires. When I call doctrine of indoor management, 2 subtopics are there. One will be the doctrine, another one will be exceptions to the doctrine. So these are the things that we need to discuss. 1, 2, 3 and 4. 4 different situations we are going to analyze. So let's try to understand one by one in detail. examination generally every 3 attempts, one time a question will come from the doctrine. I can't tell every attempt it will come, but every 3 attempts, once it will be coming in exam from the doctrines. For example, if this attempt, if they give doctrine, 2 attempts after again they will give the doctrines question. Not every attempt, but important for exam. So now we are going to focus on doctrines under the Companies Act. First, let us understand what do we mean by the word doctrine. Doctrine means principle, okay, or also called as unwritten rule, but generally followed, is called as a doctrine. Simply to understand, rule imposed by the court is called as a doctrine. Rule imposed by court is called as doctrine. Sir, I will explain in a easy, simple way. There will be Bare Act and there will be rules. Bare Act will contain section, subsection, clause, subclause, proviso, explanation, illustration. Rules will contain only the rule provisions. If something is contained in the form of a section, subsection, clause, subclause, proviso, explanation, illustration, or something is contained in the form of a rule, this we generally call it as a contents of the act. That means it will not be a separate provision. This will be treated as an act, or simply we will call it as law. But something is not there in section, subsection, clause, subclause, proviso, explanation, illustration, rule, nowhere it is, but generally accepted principle, we call them as doctrines. This is a basic introduction first to start the concept. Doctrine means something which is not contained within the act, but still followed by the courts and every other person are called as doctrines. Why I am saying this? The reason is, close your Bare Act, that's all. Because the topics which I am going to discuss will not be there in the Bare Act. Adi. Okay, na? First point is, we are going to start with what concept? Doctrines. Means it will be there in sections and rules, or will not be? Will not be. Therefore, there is no point of opening the Bare Act. Okay, na? Next. Point number 1. Then what we need to read? I have given you the charts material. Na? You need not even open your phone. You need not operate. I will show you on the screen all the contents regarding this. See here. What is a concept? This is not working. Okay, see here. What are the please, what are all the doctrines that are applicable for our examinations? First one is a doctrine of constructive notice. Next one is a doctrine of indoor management. Next one is exceptions to the doctrine of indoor management. See here, exceptions to the doctrine of indoor management. And last one is doctrine of ultra vires. So these are the doctrine of ultra-vires. Once we complete all these, then I will be giving you one illustration. We will also be doing that. Once completed, you will be thorough with the concept called as a doctrines under Companies Act. Illustration we will do in the next class. First let us complete all the doctrines applicable for your exams. 1 full hour it will take. From now 1 hour we will complete of all the doctrines. Since a doctrine is not a section or a subsection or a rule or an act, language you can use in your own language, but don't deviate the content of what is covered. Overall you can use your own language and write the answer, but don't deviate the overall content. Sir, listen carefully, see there. Doctrine of constructive notice, 5 points will be there. In the charts material, as possible, as much as possible, all the contents have been kept. 5 points. 6. Once after that, indoor management will be given in 4 other points. Later, exceptions to indoor management, 3 points. After that, the doctrine of ultra-vires, another 3, subdivided into 4 concepts again. Clear? Huh? So this is how we are going to do this. First 2 charts. This is chart number 1, this is chart number 2. Once we complete these 2 charts, we will be completing the doctrines under Companies Act. Since the doctrine is not there in the act or rule or section or subsection, charts material more than enough for the exams. Clear? Problem with the institute study material is 1 point they kept somewhere, ultra-vires kept somewhere, indoor management they kept somewhere, constructive notice they kept somewhere, exceptions to indoor management is some other place. They have scattered all the concepts without having any meaning. So let us compile everything and make a meaningful discussion out of it. So let us start with the concept of doctrines. 1 hour time. We will complete all the doctrines under the Companies Act. Okay. As I said, today we will complete doctrines and then start with the next topic in the next class. Clear? First one. Doctrine means unwritten rule of law is called as a doctrine. There are 2 types of doctrine, 3 types of doctrines: constructive notice, indoor management, ultra-vires. First let us see what is the doctrine of constructive notice. I am putting the answer before you. First let us read the content. Before that I will explain the basics idea. First one. Whenever MOA and AOA are registered, whenever MOA and AOA are registered. So what do you mean by registration of MOA, AOA? Registration of MOA, AOA means whenever we incorporate a company, 2 documents will be there. What is the document number 1? MOA. What is the document number 2? AOA. We will file it with whom? ROC la first word is what? ROC la R means what? Will do what work? Registration. That will be registered. MOA, AOA will be registered with the ROC. Once registered, they get the status of a public document. CA Foundation, I said all these. We are just reiterating the same. But still I will re-explain entire concept. Listen. Always, whenever I call about a memorandum or articles once prepared, it will be registered with the ROC. Once ROC registers MOA and AOA, they get the status of a public document. Status of public document. What do you mean by public document? Public documents are those documents which are freely accessible. I am not telling free of cost accessible. Freely accessible. Meaning is no restrictions on access. This document you cannot read, you cannot access, like that it will not be. Those are called as a public documents. Public documents are those documents which are freely accessible. I am talking freely accessible, not free of cost accessible. Example of a free public document is newspaper. Can a person, a small boy aged 5 years, as a 10 years, 8 years, can buy a newspaper? Can a person aged 80 years can buy a newspaper? Is there any age restrictions, community restrictions, language barriers to buy a newspaper? No. Anyone can have the newspaper and have the access because newspaper is a public document. But that is not a point where newspaper you will be available in the shop free of cost or payment. That means newspaper is a public document which is freely accessible upon payment. Payment is mandatory or optional? Mandatory. You have to buy the newspaper, you can read. I am not telling free of cost accessible. This is the fifth time I am repeating. Fifth time I am repeating the same one. It's not free of cost access. It is free access. Anyone can get the access. Not free of cost. May be there is a cost, may not be there is a cost. Point number one. Why you are telling all this to us, sir? MOA become public document. So what? So what means? Listen carefully. Whenever something is a public document, not reading it is your mistake. Example. I want to write UPSC exams, civils, prelims. Civils la prelims exams will be there. Date will be announced in the newspaper. Okay, if you are interested, you need to apply and you need to send your documents and you need to apply. You can write the prelims in civils. So a date will be announced in the newspaper. All newspapers date will be announced. State to state, every particular state will have the civils examination. State exams will be there. Central exams date will be same for entire India. Clear? So example, exam conducted on 4th of April. April generally prelims will be conducted in India. 4th April prelims started. Clear? It is announced in the month of November of the previous year they will announce. April applications will be out. One of the person, sorry, for example, some Mr. A didn't read the newspaper. In the newspaper announcement was made. He didn't read the newspaper. April came. He didn't apply for the prelims. Later his friend applied. He said, I am going to appear for prelims. He was surprised and asked him, how? Who told you? He said, it's there in newspaper I read. Hooray, which newspaper? Every newspaper. Hooray, I didn't read newspaper here. In my house newspaper will not come. Therefore that's not my mistake. Na? Government should tell me that it is going to conduct exam. He filed a case in the court that government is not informing him about the exam. Tell me, is it the mistake of the government? Arre, why? It didn't tell him. Narendra Modi didn't call him. Even then, no problem. Narendra Modi didn't call me. He didn't tell me that there are UPSC exams. Now tell me, is it correct or wrong? Answer. Arre, no one said me. Did anyone from the government called me over my telephone and said that there is a UPSC exam, please apply? Then, how would I know? I in my house newspaper will not come. That's your headache. Not knowing is your problem. Do you understand the point now? Not knowing is your problem. If I don't give a newspaper advertisement, then government will do the mistake. But I clearly given, I said in the November itself that applications will open in the month of April. It's your mistake not appearing for exams. Therefore, public document one advantage is there, one disadvantage is also there. What is the advantage of public document? Free accessible. What is the disadvantage? No one will inform you about that. You yourself has to know. Clear or not, everyone? That's the advantage and disadvantage of a public document. Public document, no one will tell you, but it is freely accessible. Clear, everyone in the class? Everyone in the class? Very good. So now clear, listen carefully to the point. This is an importance of a public document. MOA and AOA are public documents. Means what? Every person dealing with the company. Use the words. Everyone, every person dealing with the company. Institute will interchangeably uses the words. Sometimes they use the word every person dealing with the company. Every person dealing with the company. Sometimes they use the word outsider. They use the word? Sir, what is this insider outsider business? Listen, conclusions I will tell now, logic, everything we will discuss at the end of this concept. Listen carefully. Company is there. Company is there. Two persons will be there. Board of directors, shareholders. Clear? Or members. Instead of calling shareholders, I will call them members. Listen carefully. Board of directors to the company are outsiders. Board of directors to the company are outsiders. Members to the company are insiders in member capacity. Sir, what does it mean? Member capacity means what? Sir, I will give an example to you. I am a member of TCS. I am a member of TCS. I have also given loan to TCS. Now I am having one capacity or two capacities. Some people are not in this world. Please come back. Point number one. I am a member of TCS by buying the shares. I have also given loan to TCS. Now tell me, I am only a member. I am also a creditor. I am a member and a creditor. In capacity as a member, you will be treated as an insider. In capacity as a creditor, you will be treated as a outsider. Why is a concept we are going to discuss in section number 10. At the end of this concept it will come. Which section? 10. Section number 10. 10 I will discuss why they will be called as insiders. I will explain you one point. Company will have separate existence. Separate legal existence. Repeat. Separate legal existence. Repeat. Separate legal existence. What do you mean separate legal existence? Company and members both are one and the same or different? Company and board of directors one and the same or different? Then why you are calling members as insiders is the point we are going to discuss in section 10. Clear, everyone? Therefore, don't ask me what is the reason behind that now itself. When we come to section 10, even though you don't ask, I will tell. So the point is, members in member capacity are called as insiders. In all other capacities, member in creditor, member in debtor, member as a director, member as a any other person, everyone will be called as a outsider. Clear, everyone? Everyone clear? Point number one. Tell me what I said now. MOA, AOA once registered will become which document? Public document means what document? Reading and not reading is the headache of whom? Person dealing with the company. Means whom? Outsider. Clear, everyone in the class? First, what you have to do is, overall first you read this. Once you read these 6 points, after that I will be making analysis on this. Visible on the screen? I will make it full screen or else. First you read the content. Next we will be going into the analysis. 2 minutes time. Word to word you read properly. How many points are there? 6. You have to write all the 6 if given in exam. They will ask indoor management and constructive notice combined. 10 points we have to write totally. 6, 4. As it is you have to write. Okay na? So please see there. Completed reading? How many points are there totally? 6. Sir, see here. First point number 1. To a company, member will be treated as a insider. In which capacity? As a member, you are a insider. Focus completely on the concept for the next 40 minutes or else you are gone. I am telling you, foundational basics we will cover. Here we have to cover every point inside the doctrine in tune with exams. So no overaction. Please listen carefully. Okay. Point number 1. Memorandum of Association and Articles of Association are public documents. Are? Tell me, MOA and AOA are public document. True or false? True or false? False. Their registered MOA and AOA only will become public documents. Okay? Which one will become? Registered MOA, registered AOA will only become public document. Public documents are only registered MOAs and AOA, not every MOA and AOA. Okay, I write at my home and I will tell it is a public document. No. Once registered with ROC, they get the status of public document. Clear everyone? Point number 1. Point number 2. Registered MOA, registered AOA, registration gives them public status. 1 point over. Second, whenever something is a public document, there is an advantage, there is a great grave disadvantage is also there. The advantage of having a public document is, it is freely accessible to anyone. You need not restrict the access. But if it is a public document, from the reader point of view, it is a difficult task because public documents are not known that they are issued. Clear? Government released some notification. How would I know? You should put track on that. Example, I will tell you. Very frequently MCA gives notifications. My phone will not get any message. MCA gives notification because it didn't personally send to me. It sent to entire nation at large. Then how would I know? If you are really concerned about the notifications of MCA, it is you to check MCA website at regular intervals. Did you understand the point or not? Everyone? If it is institute like this, members joining the class will be in hundreds and thousands, max 2,000 or 1,000 or 100 or 500 or some number will be there. It is easy to send a message to each and every person. MCA message should reach crores of population in India. Is it possible? Therefore, every single notification I can't do like that. Therefore, notifications you have to personally go and check. Clear or not, everyone? This is the first point. So, public document is both advantage as well as a disadvantage is there because of a public document. Free of access will be there, free access will be there, but we don't know whether they are released or not. Point number 1. However, always it is presumed that whenever a person is dealing with the company, he is expected to have read the provisions of MOA, AOA and understand the contents of MOA and AOA in a right sense. It's also called as a consensus ad idem. I will explain this in a beautiful way with a lot number of examples. Listen carefully. Point number 1. Once for all, I am repeating for the last time. MOA and AOA once registered will become public document. Therefore, whenever a person means outsider, whenever a outsider is dealing with the company, repetition, whenever an outsider is dealing with the company, he must first read, next read. Reading is not enough, understanding. This is the responsibility of company or outsider. Example, you joined CNA, at the time you joined CA Foundation, a book will be there called as a prospectus. CA Foundation, I gave this example if you remember. Sir, I will repeat, no problem. Whenever you join CA course, institute will give a prospectus book. Once you pay the fee, gift they will give, written gift. Take this prospectus, colored pages, synthetic pages they will give. We will take that book, put in Almara. After that, we will forget. After qualifying CA, nostalgic situations, we see and cry. How I am, now I am. So you will see and we will cry for past. Maximum that only we will do. No one will read prospectus. Actually, in real life terms, no one will read the prospectus. Sorry. But institute will expect the following. The moment you came to the institute, listening, the moment you came to institute, I mean website or physically, you came, you paid the fee, institute will presume. Presume means what? Presume means what? Even though you didn't read, may not read, I will presume that you have read that. Read what? See here. CA prospectus la just a minute. See here. CA prospectus la last pages will have CA regulations 1988. CA regulations 1988. In this CA regulations, everything will be there. How institute is, what are the institute powers, what are the rights of student, what are the duties of a student, like that everything will tell, including examination, pass percentages, etc. Every single point they will discuss in CA regulations 1988. In this regulation number 39, sub-regulation number 2. In this they have written that ICAI has absolute discretion to alter the marks of a student either in a group or in a subject or in aggregate. For example, some person got, I will not take you as an example, some Mr. A have written exam. He expected 60 marks in some subject and he expected with tough determination, definitely least of the least I will get 60. He got 52. Immediately he applied for certified copies. In that 68 is there. 62 is there, say for example. 62 is there. In the marks list, how much is projected? 52 is projected in the marks list. Immediately he went to the nearest civil court, filed a complaint against the institute. Atrocity is going on in this ICAI. I got 62. This bloody fellow made it 52. Because of that 200 became 190. I failed in exam. What is going on? Let me take an action against the institute, he said. Are you listening, everyone? Yes, now you will listen, I know. So, he applied to the court. Court has taken his petition, read the complaint, what is all about. Court said that, he said that this is a situation. Court will tell to the student, go out and play. Why? First you leave the court. You have no authority to file a complaint in the court on this. Student asked, why? It was said in prospectus or not that institute have a right to alter your marks. Even then you only paid fee with enjoyment and you joined the course or not. Whose mistake it will be? Who asked you not to read? Did I tell don't read prospectus or did I hide under my seat? Don't read prospectus. Did I hide the book? Online also it is available. Are you understanding or not? Then why? I didn't tell you not to read. It's your mistake for not reading the prospectus. Therefore, like this, so many people tried to complain against the institute, but every case la court didn't even accept the application because of constructive notice. Students said, "Hey, I didn't read prospectus. If I would have read prospectus, I wouldn't have joined CA. That's your mistake. Prospectus is a public document. It is kept on the ICA website. It is given physically to you when you join. If you don't read, that is your mistake." I think everyone now understood the construct notice properly. Everyone in the class. Full clarity. Very good. So, this is a basic idea behind doctrine of constructive notice. Tell me, prospectus is a private document or public document? Not reading a public document is your mistake or institute mistake? Yes, this is realization. So, now the point. Sir, now fear started in heart, sir, what to do? A question will arise. Okay, na? Now listen. We are negative minded or positive minded? Negative minded. Over action venda. Okay, na? So, problem is, I use the word alter. You are imagining only lesser alteration. In the last 21 attempts of CA examinations, including CA final, always this clause has been used to add the marks only. Never institute deducted the marks. They know about our performance, how great we are. Institute, what it will try? One person is there in Chennai. Okay, once upon a time he is the BOS chairman. Okay, here only, Muralidharan, one popular chartered accountant from Chennai. Here only, in Chennai only, 2016, not even 16, before that, 2015 time, he is a BOS chairman in Chennai, SIRC. Sir, one seminar was conducted. At that time, we also attended the same seminar. Students also attended. That's a student seminar. Muralidharan sir is a speaker. Sir, most of the students asked the same question to him. Sir, clause is there. Is this clause really used? Etc. etc. Asked so many questions. He is a BOS chairman at that time. He immediately opened the laptop, projected on the screen, and he has shown. Though this is a confidential information, just to build confidence in the students, I am showing this, he said. See all that. At that time, he shown past 11 attempts he has shown. How much is the actual percentage? How much marks added? After adding the marks, how much is the percentage? Do you understand the point? 100 times they used only for adding the marks. Never they deducted the mark. That alteration will not use it to torture you. Institute will require a percentage. Say for example, 20% pass is required. Industry needs 20%. Only 17 passed. To reach that 3%, how much marks I need to add per subject, they will calculate. They will add the marks upfront. Like that only, previous CA final exam, like SCM and PE paper, means costing in short. That paper has 13 marks added. Tough paper came in the history. Students literally cried and came out. Then institute said that we are adding 13 marks. 13 marks added, most of the students passed. Passed, totally CNA passed. They thought that only SMB I will fail. They passed SMB, they passed the final also. So what I am trying to explain is, never institute will use it on a negative side. I use the word alter. But to grab your attention, I gave that example. Or else you will not listen. Like this only you should think. Sir, okay. So the point is, now tell me, not reading the prospectus is whose mistake? Now no problem, even though if you don't read. But the point, sir, I also didn't read actually. After failing, one fellow told me, there is a clause like this. Then I come to know. But later, after becoming faculty, I came to know that it is not used to reduce the marks. Students used to blame institute whenever they fail. Institute used class 39. నీకంత సీన్ లేదు. సో నీ మీద క్లాస్ చేయాల్సిన సీన్ నీకు లేదు. So therefore the point is, you don't have that much picture to use that clause against you. Without clause also you will fail. then why to use clause against you? That's not the intention really. Okay. See here. If you fail means even after that clause additions we failed. That is the correct interpretation. Sorry, okay, see here. Doctrine of constructive notice. Now everyone basics understood properly, yeah? Very good. Now tell me, who is outsider in my example? Sir, I and institute one and the same. We embrace each other. Not like that. From the institute point of view, you are different. Institute is different. Answer here. Me and institute one and the same, huh? Yes, I am a member of institute. So, the point is, I am a member of institute. You are not member of institute. You are a student. Student can never become an insider. Members are insider to the institute. Okay. So, sir, the point is, doctrine of constructive notice, the first thing is, public documents is the main focal point. MOA, AOA, like prospectus of the institute, they become public documents. Whenever something is a public document, it is your duty to read the document. If you don't read the document and you have gone through some wrong, you can't sue the company for that. Clear or not, everyone? In my example, can you sue institute? In this example, outsider also can't sue company. Clear, everyone? We will take classic examples for this and try to understand. So listen carefully to the point. Whenever company is there, memorandum and articles of association are there. Memorandum and articles of association will become public documents upon registration. Once they become public document, it is a duty of the outsider to read the contents of MOA and AOA and understand it in a right sense. Half the answer we completed. Understood? Yes, sir. Hope you now understood first point, second point and third point. Yes, so what institute really, so 1 second, answer, you paid the fee? Yes, at the time of paying the fee, did institute ask you, did you read prospectus? Did you read last page? Did you read 39th regulation? Are you happy? Did they ask you? Why? Presume. Enna? Everyone? What do you mean presume? Assumption. Sir, assumption is also not a correct word. Presume means it's related to mind. Tamil one. Nanikirada. Correct? Don't rag me. As far as I am concerned and I remember, Nanikirada something is there. That word. Okay. So, I am that related to mindset. Presumption means it's not an assumption. Presumption is that word exactly. In Tamil, that is a word. Actually, my brother said me. That's correct, huh? So, sir, okay. Sir, listen, please. Whoever says word is correct, kada? Then continue with the flow. So, the point is, presumption means, I will not ask you whether you have really read or not. I start presuming that you read. Then only you came to us. I didn't read. That's your headache. I didn't understand. That's your headache. I didn't even read. That's your headache. I didn't open website. That's also your problem. You are opening other websites, not institute. Hey. I'm talking about MCA. I am talking about MCA. Sir, polluted minds, I can't do anything. Sir, listen here. I am a good person. So see here. Like this you should not think. So the point is, listen here, MCA, ICSI, ICMA, that I want. Okay. See here. Listen here. You don't shout, please. So, doctrine of constructive notice, doctrine of indoor management, first we are in which doctrine? Constructive notice. Listen. First point number 1, MOA once registered will become which document? Every person dealing with the company must first read. Next read. Understand in a then doctrine of constructive notice is complied, or else company will that you read the MOA, that you read the that you understand in a actually we didn't read, but still company will presume that you read. If you don't read, that's your mistake, you can't sue the company. That's the fourth point. Outsider who has not read the contents in MOA and AOA with consensus cannot bring any suit against the company. You cannot file any complaint against the company. Everyone understood the point clearly or not? Next. So tell me, with your common sense, you answer. This doctrine will protect the institute against student, protect the student against institute. Here, who is the institute in our example? Company. Student is who? Member. Or outsider, sorry, not member, outsider. So tell me, this is a doctrine which protects against the very good. This doctrine protects the company against the outsider. So this doctrine is running in favor of against to answer is over. This is all about constructive notice. Read all the 6 points now. Once you read, say yes or no, understood or not, then we will go to the next one. Please, everyone in the class, read all the 6 contents clearly. Huh? Zoom. Zoom. Completed, huh? First 3 points completed, huh? Sir, what is PDWC? For dealing with the company. It's called as a PDWC. Clear, everyone? Okay. Now we completed 6 points in doctrine of constructive notice. Next, listen. Doctrine of constructive notice, is it really so much important if that question comes to? There is a case law that happened. Please listen. Please. There is a case law that has happened between K.V. Swami vs. C. Ramamurthy. Case was given by the Honorable Andhra Pradesh High Court. Old case law. So it was given by the court in case of K.V. Swami vs. C. Ramamurthy. What happened in this case law? Let me explain. Maybe after that you can really understand importance of constructive notice. 2 persons are there, K.V. Swami and C. Ramamurthy. This K.V. Swami is a managing director of a company. Nice, please. Listen. This K.V. Swami is a managing director of a concerned company. This company want to borrow money. Okay. This person is a money lender. C. Ramamurthy is a money lender in Hyderabad. So he is a money lender, local money lender. This person KVS, being the MD of company, approached money lender. He said that my company wants some loan of 1 crore. Can you give? He asked. He said that yes, provide me security documents, everything, mortgage deed we call. Which deed? Mortgage deed means putting the assets as a security. Those are not called as a security deed. We call them as a mortgage deeds. Mortgage deed you bring, on the basis of mortgage deed I will give you the loan, he said. Sir, a company MD KVS said that, okay, give me 1 week time, I will prepare the deed and come to you. Listen, here, who is an outsider? CRM is an outsider. To whom? KVS. Company who in which KVS is a managing director, that company will be a person and that person will become outsider to that company. Listening everyone? Yes, first tell me, CRM can blindly give loan? No. First what he has to do? Go to company. Ask for their MOA. Take the MOA. Open MOA. Read first clause, name clause, situation clause. Like this you should not think. Don't read these two, time waste. Directly go to the third clause. What is the third clause? Go to the objects clause. Sir, objects, are two types of objects will be there. Number one, main objects of the company. Next one are the ancillary and incidental. First one, main. Second one are ancillary and incidental. Now we need to check the borrowing powers of that company in the main objects, ancillary and incidental objects. Answer, ancillary. In main you should not check. Main object life borrowing is there, that becomes a banking company. Which company? Banking company it will become. It should become other object. Sir, listen. As a student I ask you, what is your objective? You will tell my objective is to become chartered accountant. My objective is to take coaching. Becoming chartered accountant is your main object. To achieve the main object, what is required? Coaching. This is also an objective. That is also an objective. But what is a more strong objective? Becoming CA is your objective. For that, coaching becomes a incidental object. Same. Like that, company ki main object is buying, selling, manufacturing, profit, etc. But to achieve that, I require finance or not. In FM, what you learn, two types of decisions will be there: investment decision, financing decision. This becomes a finance. That's the idea behind this. Hope everyone understood the concept clearly. Now listen, more points are to come. Please listen first. Tell me now, company belongs to CRM or KVS? Answer. Versus CRM. CRM is a participate, or else you can't understand. I am telling you very clearly. Next, KVS is a MD. MD of X Limited. Name the company first. Okay, X Limited. Now tell me, to X Limited, CRM is whom? First, CRM has to read. Second, listen now. First, tell me. CRM should go to company. Take the MOA. Open which clause? In objects clause, you have to read for ancillary objects. In that ancillary object, you should search for buying, selling, borrowing. Who should have borrowing powers? Company. I started reading. Nowhere loan taking power is there in the MOA. Listen to this line clearly. This will be repeated again in another concept. At that time I will not repeat. If something is not there in MOA, company cannot do that. Don't presume that it can be. Implied powers will not be there for company. I will give an example. One person has computer system. Motherboard will be there, chips will be there, capacitors will be there, resistors will be there, transistors will be there. All these will be placed on a motherboard. When you give a coding, code will be loaded in a memory called as a cache memory, and it will stand. It will go and stand in motherboard's cache memory, permanent memory. Temporary cache memory, after booting it, you will have a temporary cache, you can clear that. But motherboard cache memory gone, computer gone. It's a brain of computer. Sir, I will give you an example. If you see coding, how they do the software coding, Single small details also we have to write the code. Example, in mobile phone if you see, example sake, I will open the screen. When you, for example, when you open the phone, when you scroll it up, say for example, you can see the screen. When you scroll it up, one particular screen will go out and another will, with a transition, it will come like this. That also has to be coded. If finger is touched on the screen and it moves on the top side, it should go and other should come slowly in a transition. Every single detail they will give as a coding. If they don't write a code on anything, it will not work. That means computer will know they didn't write this code, but in their mind it is there, therefore I should work. Company is also a computer. If you don't write something, a company will not presume, oh, okay, they forgot, but I can do this. Like that, computer will not behave. Like that, company also will not behave. Understood the point or not? I didn't write something in MOA. What will happen? Company cannot do that. That's all. Sir, it is very important. Company cannot do that. In its neural schema, it was not kept. The brain of the computer will be there in a neural schema. Schema means a coding. In that you didn't write that. In you didn't write. MOA you didn't write. Clear or not everyone in the class? So you cannot do anything. Alter your MOA first. After that, in that MOA, give the lending and borrowing powers. After that, you go for this. So now tell me, who will come for the loan? Everyone see the screen. It is very good for your health. Please see the screen. First one, tell me who came? Went to whom? Who is outsider? To which company? Who is asking for a loan? He is a MD too. Who is a money lender? Who should read MOA? Should take first which document? Read MOA. In that MOA, loan borrowing is not there. Can he give or cannot give? If he give, he can't recover back the money. It becomes ultra wires. It becomes ultra wires. Those are called as ultra wires transaction. Going beyond the powers of MOA. That we will discuss separately in next session, not now. Okay. Next. I should first read MOA. Next. Change the screenplay of the entire story now. I read MOA. I read ancillary. In the ancillary, loan borrowing is there. Tick. You are saved for first part. Next, take the AOA. Whether MD is having a power or not, you should check. You open. Who have the power under articles? MD has a power. Sir, I asked, who are you? Sir, DIN number, you can check in MCA website. I am MD. He checked in MCA website. Really, he is an MD. Two things satisfied. I read. Understood in a? That we have to see now, whether he understood or not. In this company case, what happened is, articles of association, they have clearly written that mortgage deed, which deed? Mortgage deed must be signed by 3 persons. Number 1, by the managing director. Number 2, by the whole-time director. Number 3, by the company secretary. By the company secretary. Tell me who are the 3 persons that should sign? Managing director, whole-time director, company secretary. All the 3 has to sign on what? Or else mortgage deed don't have any validity. Mortgage deed means what? Can you please explain what is a mortgage? Security. Who is giving loan? No wrong answers. Who is giving loan? Some people are not in this world. Please come back. Who is giving loan? To whom? X Limited. Don't tell KVS. KVS is an agent to the company. Since the company is an artificial person, it don't have legs and hands to go and take. He is taking. KVS. Why KVS will take? You have given loan to KVS. You have given loan to company. Come from the beginning. Tell me. Who is asking for the loan? Sir, 1 second. Don't tell KVS at any time. He is only a agent. He is a dota. He is only a dota. Means what? Agent. On behalf of him I am going. Are you understanding or not? Hanuma don't have any enmity with Ravana. But being a agent to Rama, I am having a enmity with you. Are you understanding or not? So don't. So if I do something na, Hanuma has lit his tail, lit entire Suvarna Lanka and came back. Ravana didn't really get anger on Hanuma. He got anger on whom? Rama. Because I don't consider him as my enemy. He's your agent. Acts of agent are the acts of principle. So, who is the agent in this case? Who is the agent in this case? So, who is the principal? X Limited. So, always tell about X Limited only, not about the agents. Sorry, now answer. Who is taking the loan? From whom? Who should read MOA? Power is there or not there? There. Next after what he should read? MD has a power. Later another point is also there in the articles. If there is a secured loan taken, for that if you want to put company's asset as a security, mortgage deed must be signed by 3 persons. Number 1. Number 2. Number 3. In this case law, WTD didn't sign. Intentional, please. Intentionally, unintentionally, keep it away. He didn't sign. Who? Therefore, this mortgage deed is having a validity, legal validity, no legal validity. Loan given. This waste fellow CRM didn't read it properly. He read the MOA, he read the AOA, but he didn't understand that in a right sense. Instead of 3 persons signing, only 2 persons signed. Na? Answer. Yes, what CRM should have asked the company? Where is the signature of WTD? Whether he saw the book, he didn't see, whether he read, not read, after reading, understood, not understood, no one know. He didn't ask. He didn't ask. Personally, he didn't inquire anything. Okay, na? Loan given. 1 year completed. Company said that I will not pay money. CRM came to X Limited. He asked my money. Company asked, who are you? He said that, hey, I am CRM. Company said that, I am KVS, so what? You have taken loan? No, I haven't. I have taken, okay, but I will not repay. Then CRM said that, hey, I will take your assets which are kept on security. Try touching the assets of company, go. How you will take, I will also see, you go. He said that, hey, I will come with a official receiver appointed by government. I will attach your assets, I will take away. You try. Take this mortgage deed, you go to the court and file a complaint. He went to the court. Listen, he went to the court. Okay? After going to the court, CRM asked the court, sir, mortgage deed is there, but they are not paying the amount. So I want to sell the assets which are kept as a security and get my money back. Please pass necessary orders. Appoint a government authority as an official acquired person who will go and acquire the assets. Please appoint. Court said that you can't get the assets. He is also shell shocked. Why? I have read the MOA, I have read the AOA. So what? You also read like a student. You didn't read all the contents properly. Half a you read, the remaining half story is there. You didn't read it properly. Court asked it, did you read MOA? He said, yes. Did you read AOA? Yes. Have you understood? Like you, he also said yes, though not understood. Immediately court asked him, did you read really AOA? Yes, sir, I read, sir. I read, sir. Do you understood in a right? Yes, sir, I understood, sir. What is there in AOA? Sir, mortgage deed is required, they said. No, they didn't say like that. Mortgage deed must be signed by 3 persons, namely MD, WTD CS. In this, where is WTD signature? He said. Then he realized, give it, sir. Arre. I read everything except this point, sir. This time I will read. Okay, next time only you also get money, not now. Court said that you can recover loan, you cannot recover loan. Like this, you should not think. You can recover, but as an unsecured loan. If they pay, you take. If they don't pay, don't take. So therefore, loan is invalid, mortgage deed is invalid. Means what is disturbed here? Security is disturbed. Loan is undisturbed loan. So therefore, did you understand the importance of constructive notice? If you don't read properly, who is the sufferer? Outside. Now who is protected in this case? Outright we will protect the company. Sir, unintentionally they didn't sign. Then also you can't do anything. Then you would have asked me, why signature of WTD is not there? Why you are sleeping? I will do wrong only. Let the buyer beware. Kada. Okay, I will be like this only. I try to cheat you. You should be careful. Yes or no? You go outside, one product will be hanged, price will be 30, actually it is only 10. It is your problem here. You should bargain to 10. You blindly purchased it for 30, another person also said I purchased for 10, means you should not blame me. That's my talent, that's your idiocy. Clear or not, everyone? I will not write. You should ask me why signature of WTD is not there. If you would have read the articles properly, everyone understood the concept clearly or not? Now tell me, conclusion is very clear. Constructive notice is a doctrine which protects whom from whom? Favor of? Against to? Very good. With this we completed constructive notice with the case law as well. This is the first exam. Understood everyone? Next, there is another connected topic called as indoor management. Simple and crisp and easy when you understand constructive notice. A case law happened like this. Please concentrate properly. Royal British Bank versus Turquoise. Foundation law explained this case law. Royal British Bank versus Turquoise. Let us see what happened. Sir, please listen. Shall I continue? In the previous example, even though you didn't read, company will presume that you have read. I said that I didn't read. Even then what company will tell? I already presumed that you read. Actually I didn't read. I presumed. I didn't read. I presumed. Who presumed? Company will presume even though you don't read. Clearer? Now a case law happened this way. Royal British Bank versus Turquoise. In this case law, there is a money lender in the name called as a Turquoise. This fellow went to a company called as a RBB Limited. RBB Limited approached T, asked for a loan amount from him. Request for loan. Pounds 1 lakh. Tell me, who is a outsider here? T or RBB? Is an outsider to whom? Now everyone in the class, unified answer. Tell me, first point number 1. What are the minimum requirements that T should do? First take the. How many times you take MOA? Same MOA 2 times Xerox. Take MOA you said. Next what is it? Take MOA. How many times you will take? How many MOAs you will take? First one. Second one. Next. It's time to leave the planet. టేక్తే సరిపోదు, యూ హ్యావ్ టు రీడ్. ఆన్సర్ నౌ. ఫస్ట్, సెకండ్ టేక్, రీడ్, రీడ్. You do one thing. This job is very difficult for you. I will tell you, repeat. Okay, I know. First take MOA. Take AOA. Read MOA. Read AOA. Understand in a right sense. That's all. So, first you should take MOA, you should take AOA, read MOA, read AOA, understand in a right sense. Who should do all these things? In case who is that outsider? Has done everything. He read MOA, he read AOA, understood in a right sense, everything he has done. What an outsider has to do, pakka he has done everything. In AOA, it was written like this: any loan in excess of pounds 50,000 one may single person requires shareholders special resolution in a general meeting. Any loan in excess of 50,000 pounds from one single person requires shareholders special resolution in a general meeting. Now tell me, in this particular case of Turkwan, special resolution required or not required? Why required? More than 50,000 it has crossed. It requires a special resolution, but company did not pass. Directly it came to Turkwan. Turkwan read MOA, Turkwan read AOA, understood it in a right sense, and he has granted 1 lakh pounds to RBB Limited. Now RBB passed SRA, didn't pass SRA? Answer here. Now tell me, this loan transaction is valid? That means can T recover? Cannot recover? Can recover, because my mistake is not there. Tell me, passing and not passing of SR is the mistake of whom? Court case happened. RBB person standing on one side of the court, Tarkwanda on another side of the court. Court asked, tell the details of the case. Tarkwand explained everything. Court asked Tarkwand, have you read MOA? Yes, sir. Have you read AOA? Yes, sir. Have you read AOA in a right sense? Yes, sir. What is there in AOA? Tell me. Sir, it is there that special resolution has to be passed if the loan exceeds 50,000 pounds from one single person. Yes, sir. I have seen. I signed on that day. You can see my signature on that day. That's why, as a proof that you have read, you will sign on AOA and MOA. Okay, on that date you have to keep and sign. It's a proof that you read on that day. Okay, sorry. I signed, sir. You can see the date also. On that day I read and I signed there. Okay. Now, from the other side, defendant's side, you also explain the case. They said that, sir, everything is correct, sir, but we didn't pass special resolution, sir. But Turkwan didn't ask us, sir, whether SR is passed or not. Court asked, first don't do. Yes, sir. You should never do. Did you ask that person whether he read MOA and AOA? Did RBB Limited ask Turkwan whether you read MOA and AOA? No. What you have done? Presume. Everyone. Presume. He also presumed. You can only presume in this world. I cannot presume. My presumptions are my presumptions. Your presumptions are your presumptions. My presumption, your presumption may not be same because it is a presumption. So therefore, tell me now, when you did not presume, when you just presumed that he read MOA and AOA, though he did not read, why he should not presume that you passed SR? If this is his internal problem, it is your company's internal problem, not passing SR. Therefore, court case have said that outsider, if he follow constructive notice properly, he need not inquire whether internal irregularities are there or not. He can also presume that as per articles, company also done everything. As per articles in this case, what company has to do? I presume that you have passed it. Though you didn't pass, I presumed. Even though I didn't read MOA, you presumed. Now you will understand pain in presumption. Understood the point clearly? So this is the whole logic of doctrine of indoor management. Okay, na? As a concept, if you see the same, this will be the whole story of indoor management. Please read the point. Once an outsider read the contents of MOA and AOA and understand its contents in a right sense, he will be stand protected by doctrine of indoor management. Read. An outsider can presume that as far as the internal regulations or resolutions are concerned, company has complied them strictly. That means he need not inquire into internal management. This is a doctrine that operates in favor of outsider against the company. This doctrine protects the innocent outsiders against the wrongs done by company. This is called as doctrine of indoor management. Everyone understood the logic of the section clearly? Yeah? So summarize everything in your language. Tell me first, MOA, AOA once registered will become public public document. So every person dealing with the company must first read, next read, understand in a if he has not done this, who will be protected? Who will not be? This doctrine is in favor of, against to. I read everything. Then who will be protected? By the doctrine of. As per the doctrine of indoor management, who will presume that everything has done correctly inside the company? Clear? So indoor management is a doctrine which works in favor of, against to. That's all. This is indoor management concept. Everyone thorough with the concept. Last one small point. Who is an outsider? Every person other than member in a member capacity will be a outsider. Creator? Member in as a creator? Member? Member as a debtor? Answer, sir. Debtor? Directors? Everyone is, sir, outside and who come inside register office is not insider. That's a bad interpretation. Company and every person is the same or different? Different. In that way you should answer. Why member is an insider for this topic I will explain in section 10 in the tomorrow's class. But as of now answer. Member in a member capacity? Member as a creditor? Member as a debtor? Member as a advocate for the company? Member as a, for example, director? Member in member capacity is a insider. Member in capacity as a director is a. I am only a director. If everyone understood? Doctrine protects insiders or outsiders? This doctrines, two doctrines will protect insiders or outsiders? One constructive notice protect company. Indoor management protect outsider. Can I take director? Anyone, sir, for example, in this case, say for example, T is there? T is there? Who approached? Approached whom? T has read. T is whom in our example? Change example. Director. Director. He has read MOA na? He read AOA na? Understood in a right sense? He has given loan na? Company passed a special resolution? Yes or no? No, it didn't pass. Now, can he recover the loan or not? Like this, you should not think you are a director in the company. You know whether company has passed the resolution or not. Knowledge of irregularity should not be there to take the protection of indoor management. Simply, you are a director kada. You don't know whether company passed special resolution or not. In here is you are seeing any cabbage here, cauliflower here. Who you are? As a director, director say will conduct meetings. So you don't know whether meeting is conducted or not. To whom you are telling? Therefore, tell me, indoor management will protect whom? Innocent outsider. Not outsider. It to protect innocent outsider. You are a crooked outsider, Nana. You are a crooked outsider. So, therefore, indoor management will protect dash. Outsiders are innocent outsiders. Innocence means knowing or not knowing. So, you know or not as a director? Then don't do overaction. You know everything. So, therefore, the point is, when indoor management will protect you, I should read MOA, I should read AOA, understand in a right side, no knowledge of irregularity. If I satisfy all the conditions, then indoor management will protect me, because indoor management protect not outsiders, it protect the innocent outsiders. With this, we completed this concept. Everyone understood the concept clearly, yeah? So, thank you very much. Next session we will continue with the remaining concepts. So, as of now, movie is everyone clear? Yes, entire movie Companies Act clear? Yes, second of tomorrow's session we will see. Part 2 taggedele.